Hey guys, and welcome to today's video. Today, we have a couple of idiots in court that let their intrusive thoughts win and earn themselves some additional time in jail. We're gonna start in Florida, so let's begin.
Your Honor, this is Mr. Sledge in 24 CF 2745. I met with Mr. Sledge yesterday. You still want to?
Are you high?
Your Honor, I met with Mr. Sledge yesterday. Yesterday, I was informed that he was going to fire me, so I was just inquiring if he wanted to proceed with the Nelson hearing. The situation with Mr. Sledge is on October 17th, the alleged victim in this case gave a written statement saying she wants to drop the charges. As I explained to Mr. Sledge, the state's already aware that she wants to drop the charges, and they're not going to just because she's provided a written statement. So
She went to the state attorney's office and filled out a drop charge for him, didn't she?
yes, she did. So
Mr. Sledge, just so you understand that the state can go forward with charges even if the alleged victim doesn't want to.
All right.
So that's what Mr. Kleins is explaining
I'm
to you.
not studying him. What y'all talking about?
Say again.
What are y'all talking about? We need to get this show on the road then.
All right. So do you have any issues with Mr. Kleins?
He's fired. This man tried to sexually assault me yesterday. This man be tripping. He came to the jail talking about he could help me if I pulled out my pants. I told him, man, you tripping.
All right.
I don't know, man.
Have we done a competency evaluation yet on Mr. Sledge?
last week, Your Honor, Dr. McDonald went to the jail to meet with Mr. Sledge. He refused to meet with her.
Okay. Let me explain something to you, and I explained it to you last time. Mr.
Can't
Sledge,
explain
Mr.
nothing,
Sledge.
man. I don't have to do nothing. You can't tell me nothing. The lady said I don't have to if I don't want to, and I told her no, period. That's it. Now let's move forward. I ain't talking about none of
No,
that.
you need to
Done with
speak.
that.
You need to speak with the doctor when
I
she
ain't
comes.
speaking with nobody. I'm pro se. I want to move forward. Go pro
I
se.
haven't.
He's
I
fired,
haven't. We
and that's
haven't
what
had.
we gonna do.
We haven't had a Feretta hearing yet, Mr.
I want to go pro se. It's my right.
Okay, let me explain something to you. It's your right, but I still have to determine through Mr. Sledge. Here's the problem, Mr. Sledge. Every time I try to explain something to you, you start
Retarded,
talking.
man. You stupid. You tripping.
All right.
I ain't did nothing. You need to get this.
Tell me why I shouldn't find you in contempt.
Hey, man, whatever you want to do, man. I'm ready to go to trial.
Okay, well, I'm finding you in direct criminal contempt for what you just said, specifically calling me stupid.
Okay.
Anything you want to introduce as far as mitigation before I announce your sentence?
Whatever.
All right, 6 months county jail consecutive to anything he has in this case.
Can I
You want to
file
meet
an
with the
appeal?
doctor now?
Can I file an appeal?
You can certainly do that if you'd like. Are you going to meet with the doctor?
No. I'm pro se. I don't got to meet with
I haven't allowed you to do that yet, sir. We have to go through what's called a Feretta hearing before we can do
Let's
that.
do what we want to do then.
All right, set them for a Feretta hearing. When y'all want to do that?
Whenever the court is available, I'm fine.
I'll defer to the court.
Anytime.
Have my lawyer trying to direct appeal on that.
Well, you just told me you wanted to fire your lawyer, so I'm not sure who you're referring to. All right, 12:23. I'll wait for him to file his written Feretta or Nelson request, and then I'll set it for a hearing.
Alright, so that's the end of the first hearing. I do want to point out a misconception that a lot of people have, especially when it comes to domestic abusers. Just because you convince your partner not to show up in court in hopes of getting the charges dropped doesn't always mean that the charges are going to get dropped. As the judge said, the alleged victim gave a statement to the police, and the state can and will pick up the charges in many cases, even if the witness is being uncooperative. In other words, it's best to just walk away instead of putting your hands on the people you love. Now we head to our next bozo, who ended up getting remanded at his last court date for not following the orders of the court and also for arriving late to his hearing. Now this hearing could have gone his way, and he could have been granted a bond and release, but he decided it was in his best interest to open his mouth and remove all possibilities of freedom.
No problem. Mr. Evans, did you have any questions for the court at this time?
No, I'd like to know if I can get my bond reinstated.
You want to know if you can have what?
He wants to discuss bond, Judge.
I think he does have one.
Judge, this was a weird one and I can tell the court a little bit about this. Mr. Evans and he was originally scheduled for a forensic review. He was out of custody at the time. He's originally scheduled for a forensic review. And somehow, to be clear, I don't think this was Mr. Evans's fault. Somehow I got a phone call from the forensic center saying that he missed it, even though my office never received notice from the forensic center that he had an appointment. And then the court had some concerns about Mr. Evans, potentially showing up late, or not potentially, but showing up late for court. I think at that time, the court, unless my notes are incorrect here, the court remanded him pending that evaluation. He does, in full disclosure, also have a bond violation pending, which I think is part of the issue. He had a drive-through of the GPS tether exclusion zone, was the allegation in the pending bond matter. I will say, for what it's worth, when he was out of custody, he was always showing up for court, sometimes late because he's not got rides easily, but he did always show up. He even showed up late on the day he got remanded, but he showed up.
I'm not sure how your office didn't get notice of the evaluation date, because our office got notice in September. So he was scheduled for December 11th.
And I think
There's mix up because I heard it was December 1st. They told me it was December 1st. Now, how can it be 2 or 3 different days?
It's in your best interest to let your lawyer do all the talking, because there's no argument that you can make to ensure your freedom that your lawyer can't make better than you can. Nevertheless, this is when he makes the personal decision to argue with the judge, and it all begins to unravel for him.
First, it was the first. He told me.
I don't know what you're talking about, sir. I know that we received notice. I know that we received notice and on September 11th that you were going to have a
I didn't receive any notice of that.
why are you talking when I'm talking?
I'm just telling you, I didn't receive.
Why are you talking when I'm talking? Why are you talking when I'm talking?
Because I had that right.
Well, be quiet while I talk. And don't cut me off anymore. So we received notice back in September that you were scheduled for a competency evaluation in December. Whether it was the 1st or the 11th really is not germane to the issue that you failed to appear, and we had notice. So I don't understand how we had notice, but you didn't have notice.
It was the lawyer's fault. It was not my fault. If I didn't get notice, how could I be there?
That's my concern. How did the court get notice and you didn't get notice? And I wasn't even talking to you. I was talking to your attorney. So why don't you be quiet so the attorney and I can work that out, okay? Excuse me? I'm gonna ask you to be quiet one more time. I'm gonna ask you to be quiet one more time before I find you in contempt.
You can do whatever you want. I'm letting you know.
All right, you're in contempt, 93 days, Ingham County Jail. I'm not going to go back and forth in the court trying to figure out why you didn't get notice. I'm trying to have a conversation with an attorney on the record. I don't have time for this. So you're remanded. We'll see you next week, okay? Or at your next court date. Bye.
Judge Simmons is someone I like to cover. She's a no-nonsense judge who has no problem putting window lickers in jail for acting like dipshits in court. So next, we head to his following appearance, where he could have said sorry for his actions and asked for a reduction in his contempt sentence. Instead, he chose to blame his disruptive behavior on being groggy and then makes things so much worse for himself. The audio isn't the greatest, but I've done my best to fix the volume so that you can follow along.
Okay, on the record in the matter of the state of Michigan versus Caprice Evans, 25-02611, appearance, please.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good morning, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Caprice Evans, who's seated to my right.
That's something that could be flushed out further if this matter goes to trial. I think there is sufficient probable cause, though, based on the testimony, to bind over count 1, and count 2 will accompany count 1 to the circuit court. Bind over date being February 25th. Will be the date the circuit court receives the file from the district court. Not a court date for you, okay, Mr. Evans? Your next court date will be a pretrial. Your attorney will be made aware of that date. Do you have any questions today?
As Mr. Palmer had explained to me, well, first of all, I would like to get the forensics report. Secondly, Mr. Palmer was advised that he was not going to be representing my case any longer, and that different counsel would be appointed.
I don't know anything about you getting a new attorney or a new appointment. The public defender's office appointed Mr. Palmer. And if they decide they're gonna remove Mr. Palmer and put someone else, that's their business. The court doesn't have any involvement in that. He's the one who's been assigned to handle your case. Now, if you're requesting for a new attorney, and you want to hire your own attorney, then you need to get your money together and or find you another attorney. But you don't get to decide which public defender represents you. Do you understand that?
Yeah, of course I do. I'm just saying this was just.
Yeah.
Okay, I'm not sure that if that's the case, again, the court would have no knowledge and or input on which public defender gets assigned to your case. And so at this time, Mr. Palmer is the one who's been assigned. If they're going to switch that, that's up to the public defender's office. The court doesn't have any involvement in that.
Just to be clear, Judge, I did advise him that it is not anything that has to do with Mr. Evans. It is the fact that I have accepted a new position outside of the public defender's office. And so I'm leaving. There was at one time a discussion that Mr. Evans may be assigned new counsel prior to today's date so that that individual could be present to conduct the preliminary examination.
Okay.
For reasons I don't understand. That didn't happen. But I did advise Mr. Evans that I will not be his counsel after today.
Got it. So you're leaving the public defender's office.
I am,
Got
yes,
it. Okay, well, congratulations to you.
Thank you.
And so for those reasons, obviously, you would have to get a new attorney because he won't be there to represent you. Again, the court has no input of who that attorney is going to be. It'll be someone assigned by the chief public defender. Okay.
Can I address the court?
You probably shouldn't be addressing the courtroom, but when have you known me to get in the way of someone running face first into a legal brick wall?
You can.
I would like to, first of all, I would like a copy of the forensics report that I had.
Did your attorney
I can give it.
got a copy of the forensic report and can get you a copy?
Yep, I've got a note
I
about
would
that.
also like to state that on the date of the 10th of December, Mr. Palmer had called me at approximately 3:30 on that day and explained to me that I would be detained because I missed the forensics examination, which I had no knowledge of. It gave me no information of that date. I was in constant company with pre-trial and was on television, so there was no way to not have been recognized. That date been recognized for forensics. So with that being stated, ma'am, the other day, went to court on the 30th or something. I had just woke up, had no pre-knowledge of that I was even going to court. Like 10 minutes, they're like, Evans, you're going to court. I'm like, what? I had no knowledge of even it was a court date scheduled for me. So, with that, ma'am, I was a little groggy, uncomprehensive, as you might say, and this is how we ended up getting into 90 days. With that being said, ma'am, I would like to know if you would try to at least give me some credit for that, the days that I've already served on that contempt charge and reinstate my bond.
You got found in contempt because of your disruptive behavior, not because you were groggy.
Understandable, man, but I'm just letting you know that my due process of rights has to be a certain amount of time before you get to be acknowledged that you go to court. I had no knowledge.
Not for direct contempt. You were disrespectful and caused a complete disruption to me in court. Excuse me?
There was no precedent.
So now you get to determine contempt in my court.
No, ma'am.
Okay. The contempt will stand. It's 93 days in County Jail.
Arguing with the judge about not arguing with the judge is like arguing that you did need all the crayons while having a rainbow sparkle across your lips.
What about what he has done, like as far as like me not having understanding?
Well, who has done?
What he did,
Who's he?
far as
Your attorney?
Mr. Palmer. I stated that on the 10th. He called me and said that I missed a court date on the first.
He didn't do anything. So you're trying to blame it on him that you missed the
I didn't have any knowledge of my competency hearing.
Okay, so there was more than two things going on here. There was also a court date scheduled here for December 11th that you didn't appear.
No, I did. I was here. Yeah, when I got here, you weren't here, and Mr. Palmer was not.
Just to be
This guy
clear,
right here, this guy was here, and there was a
He-
black lady over there that was there.
Judge, just to be clear on that date, he did appear eventually. By my notes, he appeared a couple of hours afterwards. I think he had transportation issues.
And he was
Well, I
remanded
was
for
stuck-
failure to appear
Yeah, I
to
was stuck, I
the.
was stuck in the snow. But what I'm saying, is, I'm asking you that, what is the deal with him not giving me, I didn't even have acknowledged that I had a competency hearing date, and I was remanded on the next day that I went to court. You see what I'm saying? So, like, I shouldn't even been in jail. I should just now be going to jail. But I'm like, there's like 60 or 70 days of my life that, they're unaccounted for, and he's responsible.
He's responsible for 60
Man,
days of
he
your
did
life.
not give me, he didn't.
Man, sir,
I'm trying to
see,
say,
this is how you got here in the first place.
Ma'am, he did not
This is how
give
we
me-
got here in the first place. Did you give me an opportunity to finish my sentence before you cut me off to yell over me?
Well, that's what I was.
No, I'm asking you a question. What was my question I was about to ask you?
You didn't finish it.
Why? Because you cut me off.
Well, man, you cut me off too.
No, I didn't. And if I did, I get to cut you off at a portion that I need clarity for. I am the one running the court, not you.
I understand. Well,
So when I cut you off, it's because at this very point, I need some clarification. So you have to stop to allow me to get clarification right there. Do you understand
I
that?
understand.
So you're saying that you did not know that you were supposed to have a competency evaluation, and that Mr. Palmer was responsible for letting you know that?
Yes, he was.
It's fine.
Judge, I think that's actually true. I want to be, I'm an officer of the court, and I think I absolutely have an obligation to be
I agree.
100% truthful with the court. So I'm not going to try to hide anything here. I was not aware, and I've been looking into this as to why, but I did not see the competency or the order for his appointment until after the fact. I have some suspicions on why that happened. I have some suspicions about why that happened, and I'm just going to say that regardless of why I think it happened, it is ultimately my responsibility. I don't want to pass the buck. I don't want to try to make the court think I'm passing the buck to anyone else. I will fall on the sword and take responsibility for that.
So to understand what they're talking about, the lawyer is doing his best job to take the blame for the defendant for not fulfilling his competency requirements, which he ultimately did while he was in custody, and they found him competent to stand trial. However, the judge is not budging on the contempt sentencing, and when you are as dumb as a bag of dicks, anything you say can and will result in even more time for an additional contempt charge.
What I will say is that, and so I think to some extent, Mr. Evans is correct in what he's saying. And I don't want him
That
to
he
be.
was remanded, but it was not his error. It was he did not have knowledge.
I think that's true, Judge. And one of the things I just want to remind, to at least to my recollection of what happened. I started to address this very issue at our last court hearing, and then Mr. Evans was also talking, I'll put it that way, while I was trying to make the record, and the court found him in contempt before I could really get into that issue.
I didn't find him in contempt for talking.
Or for speaking over you and interrupting the court.
No, he berated the court.
Right. I'm not trying to.
And he thinks it's funny.
I understand, Judge.
He said that he thinks it's funny. Listen, if there's.
This is following the court, so.
Excuse me?
This is following the court, so for what?
I don't know what you're saying.
You don't know what.
I didn't hear what you said. I don't know what you're saying.
Fraud of the court is?
Fraud. I didn't know what you were saying. I wanted you to repeat it. What's fraud on the court?
Fraud of the court.
It's not fraud of the court. The court has there was the responsibility of your attorney to notify you. This is what this says, that you were scheduled for an appointment with forensics, which the court ordered you to undergo some forensics. I don't know what the breakdown between you and your attorney was, because that's nothing to do with me. That has to do with you and your attorney. If there was a breakdown in the communication where there was your attorney didn't get the notice, or your attorney did get the notice and didn't get it to you, that's between you all. Before he could address that, which was last week, or a week ago, a little bit over that. before he could address that, you became disruptive and we could not carry on a hearing. So I had to remand you because I couldn't get you to be quiet over there.
That's not true, man.
Except that is true, and it was recorded on the court's record. Any other lies you want to tell the court?
It's not. This is not up for debate. This is recorded in open court.
Yeah, but
It was not. It's not. You can feel free to FOIA and or subpoena a copy of the record if you would like to.
Yeah,
The court made its ruling. Then the court stands by the ruling, regardless of whether or not there was an error made by your attorney. Does not give you grounds to come into the courtroom and be disruptive.
We violated my rights.
And then I didn't violate your rights. You came in here today and tried to say the reason why you were disruptive was because you were groggy. Now it's because your rights were violated.
Ma'am, you misinterpreted.
You can be excused. You can be excused. I can carry on the remainder of the hearing without you. You're all set. You're all set. You're all set.
I know I am set. You lost the words here.
Yep. You can get another 93 days. All set.
Yeah, whatever.
Yeah, another 93 days.
Whatever, kid.
Well, there's another 93 days. I'm sure for the next 6 months, he'll be telling everyone in jail how he showed the judge while wearing prison orange and having jailers tell him when he needs to be up, asleep, showering, and shitting.
He was not found in contempt because he was talking. It's because he's disgustingly disrespectful.
Your Honor, I'd like to go a step further. I was there for that hearing.
Thank you.
Your Honor was attempting to figure things out with the forensic review process with Mr. Palmer. And you turned at one point and said, I'm trying to figure this out for you, something along those lines. And that's when you were yelled at by the defendant over Zoom. So I'd just like to put that on the record as well, that you and Mr. Palmer were trying to resolve the issue when you were interrupted.
Now, well, it's consistent with the behavior that we've seen of Mr. Evans throughout this matter. And so that's neither here nor there. It's unfortunate that he was not the person who was at fault, it sounds like, for missing the forensic, but that does not give him grounds to come in and disrespect this court. And he will not get credit because of your error for coming in here, A, calling me out of my name, B, disrupting the process. So that's that. And he's getting an additional 93 days for contempt of court today that will be served consecutive to the one he's serving now.
In other words, play stupid games, win stupid prizes. Alright, so that's the end of today's video. I have a couple of good videos coming out throughout the week, and the last one is a sovereign citizen jury trial that you definitely don't want to miss. So if you liked the video, hit the like button. If you disliked it, hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic, and I'm out.